So salient features of Indian Constitution. Okay, what are the main features of Constitution of India? Now, when they ask you what are the features of a certain thing, you can write anything that is given in Constitution. Like there are different topics, different areas are being covered, right? All of those also you can frame into like a feature. Okay, here I have mentioned some features that we will be discussing. Okay, here also you can start your answer with a intro that Constitution of India is supreme law of land. It provides for fundamental rights, DPSP, duties of citizens and all that stuff. It was adopted on 26th of November 1949 and it came into force on 26th of January 1950. Then you can move on to features of Constitution. That the main features of Constitution of India are, first of all, lengthiest written constitution. Okay, when we talk about constitution, there are countries like we mentioned, Israel, New Zealand, Saudi Arabia, UK, Canada, they do not have one codified constitution. But if you talk about India, it is one of the longest constitutions in the world. If you look at this document itself, 402 pages. You are reading this subject in 2 different semesters, Constitution 1 and 2. That means it is a very, like elaborate thing, right? That is why it is called that. It is a lengthiest written constitution. It's very elaborate. Lot of things are taken into consideration. Total, how many parts are there? 22 parts originally in 1950 when Constitution became applicable, right? At that point in time, we were having 22 different parts, 395 articles and 8 schedules in the Constitution. As of now, because of amendments, there has been addition of provisions. So we have 448 articles, 25 parts and 12 schedules. This number you can remember, it is very important. Okay, so that means Constitution of India is lengthiest written constitution. That is one feature. Okay. Next is drawn from different sources. As in Constitution of India is not like a very original thing. It is called as bag of borrowings. As in lot of provisions we have borrowed from foreign countries and we have framed Constitution of India. Fine, we might have made some changes here and there to make it suitable in India's situation, but still we have borrowed a lot of provisions from different countries. It is also called as a bag of borrowings. That is also a feature. Okay, like we have a basic structure such as federal scheme, judiciary, governor. Some provisions we have borrowed from Government of India Act 1935. Fundamental rights we have borrowed from America. DPSP we have borrowed from Irish Constitution. Cabinet form of government we have borrowed from British Constitution. Right, like that, different countries we have borrowed different provisions. Like whatever we saw is working very good in a certain country, we tried to borrow that concept. Okay, so it is called as a bag of borrowings. Single constitution for both union and state. That is why when you look at the constitution, you see Constitution of India. We don't have anything like Constitution of Karnataka, right? It is one single document that is applicable in entire India. In this constitution itself, you see provisions relating to central government, provisions relating to different states, provisions relating to union territories also. Okay, for states also, one single document we are having. We don't have multiple constitutions, it's just one single document, both for the union as well as for the states. Okay, then rigidity and flexibility. There are some provisions which we can change easily. There are some provisions which are somewhat difficult to make changes. And provisions relating to amendment are given under Article 368 of Constitution, which is a combination of rigidity and flexibility. Okay, most like Parliament is having power to make changes in Constitution, right? But even though Parliament is having power, there may be some provisions which would affect the states. Their Parliament cannot simply make the changes, but they would need ratification of more than 50% of states. That means more than 50% of the states should approve or should be in favor of that certain change. Only then change can take place. That is why we say rigidity and flexibility. Some provisions, it's very difficult to make changes. Okay. Then we have secular state. So what does secular mean?
Certain articles.
Yeah.
Certain laws or something.
Secular
Certain
as
articles.
okay. So secular as in state, secular state means all the religions which are present, they are given equal protection and support. We don't have a religion of the state, right? But all the religions would be given equal importance. That's why you would see there are temples also, churches also, masjids also. For all the different religions, they are given that freedom. That is nothing but a secular state where you would have freedom to practice, profess, propagate any religion. Even when you look at part 3 of Constitution, right, there is articles 25 to 28 that provides you religious freedom, and that is a fundamental right which you are having. That is guaranteed to you. Okay, in addition, it provides equal treatment to all the religions by government and equal opportunities to all the religions. That is how we see India is a secular state. As such, there is no religion of the state, and government also should not discriminate amongst different religions. Next one is supremacy of Constitution. So Constitution of India is what? It is supreme and not the handmaid of either center or the state. Whatever is written in Constitution, that is supreme. All the other laws that we have, that should follow or abide by what is written in Constitution. If a law is there which is violating provisions given in Constitution, that law itself will be declared as unconstitutional. That law itself will be considered as void. It is that important. Okay, so supremacy of the Constitution. Constitution is like the topmost law that is applicable in India. Then we have division of powers. Okay, so Constitution of India provides for a federal form of government. Federal means we have central government plus we have state government also, right? We have central government or union government plus there is government of Karnataka, government of Madhya Pradesh, government of Maharashtra. Like that, we have government for states also, right? And the power of federal government are divided between center and state. Whatever different areas are covered, right? Powers are clearly divided between center and the state government. Constitution itself mentions that these are some areas where central government would have power. These are some areas where state government would have powers. And these are some areas where both the government would have powers. That is why we have something called as different list, okay, union list. As in, there are these 97 subjects where only central government is having power. Then we have something called the state list. There are these 66 subjects wherein only state is having power. And there are 47 subjects called as concurrent list wherein both central and state government would have power. Like that, powers are also clearly divided, so there is no confusion, conflict, or anything between central and the state government. They are given enough powers and functions so that they can focus on their own specific areas. Okay, that is also one of the features of Constitution of India, division of powers. Then independent judiciary. Judiciary as in the courts that we are having, right? So independent judiciary as in judiciary should be independent from other organs of government. It should be free from the executive, like from ministers and all, right? Judiciary should be separate and independent. It should not be dependent on the ministers for their appointment, transfers, promotions, etc. So that they can give a decision freely. They don't need to worry about their job, transfers, and all that stuff. Whatever is right, they can give a decision based on that. Okay, so in India, the Constitution has provided for a Supreme Court, and every effort has been made to see that judiciary is India is supreme and independent, so that it is not dependent on any other organ or anything. It can give decisions properly. Okay, then we have federalism in India. States are also given enough freedoms. They can also take care of things that are happening within their state. They would frame their own laws. They will take decisions their own self, right? Like during this COVID-19, we have seen, right, that Prime Minister Modi said there would be no more nationwide lockdown. But then he was having discussions with chief ministers of all the states that if you feel like your state is having some trouble, you can impose night curfew or whatever you feel like. That means state is given the power that you take into consideration the situation going on in your state and then you take a decision. As such, union was not imposing anything, right? This is nothing but federalism. States are also given enough powers to take care of certain things happening in the state. Okay, is this part clear?
Yes, ma'am.
Any point you want to be repeated?
Ma'am, can you tell the federal again once?
This one, federalism.
Yes, yes, ma'am.
Federalism basically means that it's not one government that we have. In entire India, it's not one government. It's not like Prime Minister, President, and his cabinet. Okay, apart from union government, we have state government also, who will take care of what is happening in the state. That is nothing but federal. That powers are divided in two groups, central government and state government. In state government also, we have like municipal bodies, we have panchayats and all that, right? That means central government would not have that much of time that they would take into consideration each and everything that is happening in the state, right? So state governments are also there. Like right, few days back you saw, right, that colleges and schools were closed for 3 days because of that hijab controversy. That decision was taken by Karnataka government, right?
Yes, ma'am.
So in that case, Karnataka government, how could they take a decision? Because they know how serious of a matter that is. But central government sitting in Delhi, they might not have like a clear understanding of what is happening in Karnataka or how serious is the matter becoming, right? That is why we have federalism, as if central government is there to come wherever needed, but states are also having their own governments. They would take care of the state. Okay.
Okay, ma'am.
Then we have parliamentary form of government. In India, we know, right, there is parliament. And we have two different houses also there, Lok Sabha and Rajya Sabha. Right? So this parliamentary form of government, this concept is also added in Constitution, and it is added from Government of India Act 1990. That introduced that, okay, there should be two houses, so that whatever laws Parliament wants to pass, two different houses, two different groups of people would analyze that law. They would raise questions so as to ensure that no bad law can be passed, right? Because when a lot of people are involved in that decision-making thing, there is less likelihood that a bad law will be passed. That is why we have parliamentary form of government with two different houses, Lok Sabha and Rajya Sabha. Okay, then we have single citizenship. We have one constitution plus we have single citizenship. We are all citizens of India. We are not like citizens of India plus citizen of Karnataka, citizen of Maharashtra. No, we are all having only one citizenship. As such, we don't have any citizenship of the state. That is nothing but single citizenship. We are all citizens of the country. Okay, and same ways we have laws also, Citizenship Act 1955, which is introduced by Parliament. That same law is applicable on all of us. Okay, then we have something called as Directive Principles of State Policy, or in short, DPSP. So directive principles of state policy are nothing but some directives, some instructions given to the government that government should try to follow or try to provide these certain things, that government should try to provide assistance to someone who is in need, someone who is an elderly person, someone who is unemployed and all that. Okay, so there are some guidelines given in part 4, articles 36 to 51, that government should do this, government should do that and all that. These are non-justifiable, as in you cannot go to the court. Even if government is not providing that, you cannot go to the court, because based on their ability, based on the resources available, government would try to provide it. If they are not able to provide all of that also, you cannot go to the court. Government would try to provide slowly and slowly. Okay, then we have another concept called as fundamental duties. As in, we as citizens are having some duties towards the state. And these duties are added in part 4A of the Constitution. As of now, we have total 11 duties. As a citizen of India, we have 11 duties to perform. Okay, so these duties are mentioned in part 4A, and we have like an obligation to perform it. As such, no punishment is given in part 4, even if we are not following, but we are expected that we perform our duties also. Okay, and lastly, we have emergency provisions as well. Okay, like there may be some situations where it's extremely difficult to deal with the situation. There, it is called as emergency. Who will have power, how things would happen, everything is mentioned there. Okay, so emergency provisions are given in part 18 of the Constitution, and there are 3 different types of emergencies. National emergency, then we have state emergency and financial emergency. Okay, we have 3 different types of emergencies mentioned. Like right now, what is happening in okay, so this Russia war, right? That war kind of a situation, if it happens in India, it would be considered as national emergency. Okay, we had 3 such emergencies, like one president imposed, one was China attack, another one was India and Pakistan war, right? So in war-like situations, emergency would be declared, how powers would be exercised, how things would happen. Those provisions are also given in Constitution of India. Okay, and after that, you can put a conclusion that Constitution of India is like the supreme law. It is providing for all the different things. It is Constituent Assembly has passed it, was adopted for people declaration. Parliament cannot override the constitution. Whatever is written in constitution, we need to follow it. It serves as supreme law of the land, and whatever other laws we have, they derive validity from the constitution. Nothing can go against the constitution. Okay, is this part clear?
Yes, ma'am.
So these are different features of constitution. This is a very common question. I think I have seen in those 2 question papers, like back to back, this question was asked. Okay, so you can go through this part. All right.